height, things like that.
Glenn, maybe Jewel, just for the public's sake, could you just maybe talk as to future land use or any land use item versus zoning, and why is quasi-judicial and one isn't, and what that really means for us?
Sure. Your land use cases are considered legislative in nature, and zoning is considered quasi-judicial. So under legislative actions, it's really the Board of County Commissioners sitting in its policy-making role is how that's considered under the law. So you have pretty broad discretion in making those decisions, and probably importantly, those cases, if appealed, there's a much more deferential standard of review granted to the deciding body, which of course would be the county commission. On quasi-judicial matters, you know, they are kind of what the title says. They are judicial in nature, where you all, rather than making policy and making some of these decisions about, like what Glenn mentioned with some of the bigger, 50 acres and then some, those really are policy decisions. And that's the way the law characterizes them. Under the quasi-judicial, you're really looking at what you're really doing is acting somewhat in a judicial capacity, where you are applying your land development regulations and comprehensive plan to the specific property in question. So you're really applying the law to a specific set of facts. And that's a much different process for a lot of reasons that I know you all have heard me talk about with you both here and individually before. Some of the big differences, well, let me back up. You have still a pretty deferential standard of review on appeal, but not as deferential when it comes to your legislative actions. So one of the big distinctions, here at the public hearing, you're going to see people sworn in for your quasi-judicial hearings to provide testimony, but not necessarily for your legislative actions. For you all personally, probably one of the bigger distinctions is the ex parte communications, meaning communications that you may have with anybody about the case coming before you. Those are prohibited. So law presumes that ex parte communications are prejudicial to the parties to the proceeding, the parties being really the property owner. So you can't really have those conversations. And you all know that I routinely advise you against having those conversations on your zoning matters. You have other items that come before you but are quasi-judicial, but for purposes of this conversation, your zoning matters are the ones where you cannot be having those conversations with anybody outside of this public setting.
And again, I think for us, it's if those do happen by chance, then we need, when we come to the hearing itself, we divulge that information. And what happens at that point? Absolutely.
As you all know, you should be avoiding those. But in the instance where they do happen inadvertently, which is of course possible, you should disclose on the record at the public hearing that you had that conversation. You should disclose the substance of that conversation and with whom that conversation occurred.
Thank you. Go ahead, Glenn.